Hi, I'm David Marchant, the founder of OffshoreAlert, which investigates participants in high-value cross-border finance with an emphasis on high-confidentiality jurisdictions. Our specialty is exposing investment fraud while it's in progress. Enjoy our content.
Hello, everyone, and welcome to the panel on domestic and foreign whistleblowers, the growth and spreading reach of U.S. programs. My name is Eric Havian, and I'm the moderator of the panel today. And I'm very pleased to have an extraordinarily distinguished panel to present to you today. First is Jane Norberg, who's Chief of the Whistleblower Office of the Securities and Exchange Commission. Next, Christopher Ehrman, who's the Director of the Whistleblower Office for the Commodities Futures Trading Commission, and Dawn Applebaum, the Program Manager of the Whistleblower Office at the Internal Revenue Service, otherwise known as the Big Three. These are the most substantial agency whistleblower programs in the United States, and you are hearing from three of the leaders of those programs, and we'll be presenting to you many topics, including recent developments, practice pointers, and other things today in our presentation. So without much further ado, since we have a very limited amount of time available, I'm going to turn it over to our panelists to give a brief synopsis of their programs. If you have questions for us, you can put them in the chat, in the meeting chat application, and we will try to answer as many of those as we can. Let me start in reverse order. Dawn, do you want to give a brief summary of the IRS program?
Good morning. My name is Dawn Applebaum. I'm the Program Manager for the IRS Whistleblower Office. The IRS Whistleblower Program has just reached their 14th anniversary. We have awarded close to $1 billion in awards. And I'm looking forward to discussing this program along with Jane and Christopher today.
Thanks very much. Next we can go to Chris. Do you want to give us a quick summary of the CFTC program?
Absolutely. We're a product of Dodd-Frank, as is Jane's program. We were created in 2010, July 21st exactly. The more important thing is what the CFTC does. We're a lesser known agency. We have a very small footprint, but a very important one. We're the independent agency that regulates the derivative markets in the United States. These include things like futures, options, and most importantly, swaps. And we also, while we do not regulate cryptocurrency, as a prudential regulator, we do have anti-fraud jurisdiction over any potential frauds involving Bitcoin and other virtual currencies. To this point, we've paid out roughly $120 million in awards since our inception, and that relates to about $1 billion in monetary sanctions related to those actions.
Thanks very much, Chris. Jane, would you like to give us a short description of the SEC's program for whistleblowers?
Yes, good morning. Thanks, everybody. And before I begin, let me just start with a disclaimer that anything I say here today are my own views and are not necessarily reflective of the views of the commissioners or the other commission staff. As Chris had mentioned, the SEC's whistleblower program was developed, enacted under the Dodd-Frank Act, and we are 10 years in since the effective date of the program. And over this time, we have paid whistleblowers over $700 million. As you all know, the program, as was the CFTC's program, was enacted to incentivize individuals to bring specific, timely, and credible information to the SEC. And if that information leads to a successful enforcement action where more than $1 million in monetary sanctions are ordered, then that individual may be entitled to receive an award of between 10 and 30% of the amounts collected in this action. And looking forward to getting into a little bit more detail around awards and the last fiscal year.
Thank you. And I will save Dawn and Chris the effort of also saying that their views are only theirs, nobody else's. not the children in their household or the other people in their agency. My views, on the other hand, are fully binding on Constantine canon. No, I'm just joking about that. All right, so I have a bunch of slides that I included here that are really only for purposes of giving folks information if you want to look at them later. I'm not going to spend time discussing them now. I'm just going to walk through them. They show the growth in the various programs. You'll be able to see, as well as whistleblowing trends. So there's the growth in the SEC. You can't read that print on there, but if you download the presentation, which will be available to you, you still won't be able to read the print, but it'll be a little bit easier than it is on this screen. It will show you the different areas for international whistleblowing, which countries are generating whistleblowers for the SEC. This shows the SEC's various tips and what sort of subject areas they are in. And here you see the similar growth in the CFTC. You can see all these bar charts are kind of going up, 36% increase from the previous highest years. The IRS program is a little more stable because it's been around longer. The IRS programs of various stripes have been around for a very long time, and the most recent big amendments occurred about 25 years ago that guaranteed much bigger rewards than had previously been given. So that's why you see the IRS stuff. But the numbers are quite large for the IRS because it's a mature whistleblower program. Here are some awards. You can see the numbers are pretty big. Whistleblowers are receiving quite large awards from all three of these programs, especially considering the CFTC and the SEC programs are only 10 years old, and these cases have a long gestation period. So from there, I am going to turn this one over to Jane to start talking about, there are some recent amendments that the SEC passed in 2020. They're very significant amendments to that program. And I think they're by and large quite positive, and I'm going to let Jane take over the discussion of those. Jane, you're on. Let's start with this one.
Absolutely, thanks. And this past year when the whistleblower rule amendments were adopted, it was really a momentous year for the program. So not only did we adopt amendments, but it was also a record-breaking year as far as the number of individuals and dollar amount of awards that we had paid. We basically tripled our output this year compared to any other fiscal year. So in fiscal year 2020, the Commission awarded 39 whistleblowers about $175 million. And that's about a third of the total dollars awarded and individuals awarded since the beginning of the program. And, just a little 2 months into our new fiscal year, we've already awarded 12 individuals about $166 million. And I would be remiss if I didn't mention our largest award to date of about $114 million that we just paid to a single whistleblower about 2 months ago. And so turning to the rule amendments, which was also the big news from last fiscal year. So the rules are actually effective today. So they were published in the Federal Register, and so they're actually effective today. So this is actually a great opportunity to talk about them. One thing I did want to mention right up front before I forget. So as of today, the effective date of these rules, the Commission has adopted a new form, WBAPP, which is the form that you submit to claim an award. It is now up and live on the website. Please make note of that. Please use the new form. There's a 30-day grace period to use the old form, but after that, we're going to have to start rejecting them and sending them back for everyone to use the new form. So just wanted to highlight that new form WBAPP is on our website. And then there'll also be new FAQs around the rule amendments that are going to get posted just a little bit later today as well to help you kind of navigate the 200 plus pages of that adopting release. And one other thing I did want to mention, because there's a lot of stuff in these rule amendments, we do have a public hotline that I invite you and encourage you to call if you have any questions or if you're not clear about some of these rule amendments. And that number is 202-551-4790. We have attorneys who will return your call if you leave us a message and are happy to talk through these with you. So The rule amendments were intended to provide transparency, efficiency, and clarity in the processing of the whistleblower award claims. And I do believe that these amendments are very positive and will get more money in the hands of more whistleblowers in certain circumstances. So if the recipient is going to receive an award that would, in the aggregate, be $5 million or less, then there's a presumption that they should receive a 30% award. There's a couple of caveats there. There have to be no negative factors that are applicable. And when I say negative factors, I'm talking about unreasonable reporting delay, culpability, or interference with the company's internal compliance process or reporting programs. None of those things can be present in order for the presumption to apply. And then the claim can also not trigger Rule 21F16, which is concerning some really culpable conduct. And then the presumption can also be overcome in certain circumstances. So if the whistleblower's assistance was limited, meaning somebody came in, they gave us a tip, it pointed us in the right direction, but they really didn't provide any assistance beyond that. Not because they were unwilling, but maybe they just had no further information. And the majority of the case was uncovered through the investigative efforts of the staff. Then that maximum 30% award percentage can be overcome in that case, and the individual will likely get less than 30%. And there's also a catch-all that if providing this enhancement would be inconsistent with the public interest or promotion of investor protection, then the commission may decline to give the maximum 30%. An example of that is like if the whistleblower engaged in securities laws violations that were unrelated to the conduct that they reported on, but nonetheless were still engaging in securities laws violations, then the commission in its discretion could reduce that maximum award. It's really important provision because historically over 75% of the awards given out under the program had been $5 million or less. So I actually think, again, getting more money in the hands of more whistleblowers is really critical with that provision. And then another provision I wanted to highlight is the Form TCR provision. So this to me is actually really important to highlight here today. It is absolutely critical that you submit a Form TCR at the time you provide the information to the commission. If that doesn't happen, if you didn't know that there was a Form TCR filing requirement, it's okay. This rule gives some flexibility here. So the whistleblower has to submit the information on a Form TCR, first of all, either via mail or fax, through the commission's online tips, complaints, and referrals portal within 30 days of first providing that information to the commission. So let's just say sometimes attorneys will call enforcement staff and see if we're interested in a particular matter, or if it's something that it really is a securities law violation, but they give us enough information that we can enter a tip on it. So that's day one. Within 30 days, we need to get that Form TCR where you're checking the box that, yes, I want to be part of the program and I'm signing it under penalty of perjury. That is what is going to ensure that you are eligible for a whistleblower award. You're not going to be knocked out of the box for this procedural deficiency. There is another exception that has been built in, another waiver, which I actually particularly like because I think this helps a lot of people. So let's just say you don't know that there's a Form TCR requirement. You gave the tip, you put it in writing, but you didn't put it on this Form TCR. Within 30 days of learning of that Form TCR requirement, you have to get that form in. As long as you get it in within those 30 days, there is an automatic waiver. It's not discretionary, it's actually automatic. So we may come back to you and we may say, when did you learn of this Form TCR filing requirement? And if you say, it was X date, and then I put in the TCR within a week, you're gonna be fine. If you say I put in the Form TCR 3 months later, it's going to be a little bit harder. That said, the commission also built in discretion that they still have their 36A exemptive authority to waive the Form TCR requirements in appropriate circumstances. That said, please don't rely on that. I highly recommend that as we're sitting here today, if you're like, this is the first I'm hearing of that Form TCR requirement. Please put it in. If you already put in a tip, didn't know about the Form TCR requirement, please submit the Form TCR.
Jane, if I could just put a pin in that to emphasize that for practitioners, as lawyers, if someone shows up in your office and said, hey, I talked to the SEC a few weeks ago about this, or I talked to the SEC 3 months ago, you should start the clock running, because that will be deemed, the client hiring you will be deemed constructive knowledge on the part of the client that they know the requirement, and that'll start the clock ticking if it hasn't already begun to tick. Anyway, sorry, Jane.
That's exactly right. Nope, that's exactly right. Whistleblowers are on constructive notice of the TCR filing requirement if they are represented by counsel. So counsel saying that they didn't know about the requirement is going to be a really tough hill to climb. So again, get that form in if you haven't already. And, again, the commission does still have this exemptive authority. They'll use it in appropriate circumstances, but there's certainly no guarantee. So highly recommend getting that form in. One other rule amendment that I wanted to highlight is basically a rule amendment that will allow us to devote more time and resources to the processing of meritorious whistleblower award claims. So we sometimes get a lot of claims for awards from people who, either didn't put in tips or put in one tip, and then they think that they are eligible for, 20, 30, 40 matters that get posted. And clearly that's not the case. And it's very frustrating to me because these individuals are tying up the award process, not only for my team from a resource standpoint, but also for paying out meritorious whistleblowers. So what the commission did is put in place something I call affectionately the 3 strikes rule, which is basically if somebody puts in 3 or more frivolous award claims, then they can actually be barred from the program. There are notices built in there. We are not going to just bar someone without you getting notified ahead of time. We're going to give people a right to withdraw those first 3 claims. But after that, if someone continues to submit clearly frivolous claims, then we can, the commission can bar them from participating in the program like forever. So that I think will be very helpful to clear out some of the more nuisance claims. And in addition, there's something called a summary disposition process, which will actually help us again increase efficiencies. So what this is for people who aren't necessarily frivolous, but the claim got put in and let's just say the tip got designated for no further action, and it didn't go to enforcement staff. So that's just one example. There's other examples of matters that could fall into a summary disposition process. In those instances, we can move that claim forward a little quicker because there's a shortened time frame for which someone can seek the record and ask for reconsideration. And the summary disposition actually comes out of my office. So the Office of the Whistleblower is actually issuing it, not the claims review staff. So I think that will help us move forward things a lot quicker. One other thing I just wanted to mention, because this involves it can involve the IRS program. So there was some clarifying, the amendment basically codifies the commission's approach to determining whether an action is a related action. So this is important to note. So if there's another entity that you provided your information to and you're seeking to get paid under the SEC's whistleblower program for a related action. And let me take a step back in case somebody doesn't know this. In the SEC's program, if you are eligible for an SEC whistleblower award and your information was also shared with, say, the DOJ or another eligible organization, it's possible that that person can seek an award on that related action through the SEC's program. So, but what became apparent and something that wasn't thought about originally when the rules were put into place is that there are other whistleblower programs. And with and honestly, like with the rise of these whistleblower programs, like that are just kind of popping up all over the place, what we don't want to have happen is to have somebody be able to get double paid from 2 programs, because I don't think that's the intent. The intent is that our program, if there's a related action and there isn't another program for that person to get paid from, then the SEC will pay it out of our investor protection fund. But if there's another program, such as the IRS whistleblower program, then the SEC will not consider that entity's action to be a related action unless the SEC finds that our own whistleblower program has a more direct and relevant connection to the action. And another entity's actions are not likely to qualify as related actions where they don't have clear, explicit, and direct connections to conduct governed by the securities laws. And so I just did want to highlight that one because I think that's important too, so that people understand they've got to know what whistleblower programs are out there, so that if you're giving something to us and something to the IRS or the DOJ that implicates tax laws, make sure you're also applying to that IRS program, because you likely, unless the conduct is clearly and directly connected to the securities laws, you're going to have to seek the award from that other agency. And I think that's as far as I'll go with the amendments, because I don't want to take up the whole time just on these, unless, Eric, there was something else you wanted me to highlight.
No, I think that you've highlighted the most important things, and the only thing I would emphasize there is that it surprised me to hear that 2/3 of the awards that you've made to date are at or near the 30%. So that's great news for whistleblowers. So and then we can skip over digital realty. Just quickly, I'd want to add that you have to, if you're arguing retaliation. After the Supreme Court's decision in digital realty, if your whistleblower says you've been retaliated against, you must have reported to the SEC before the retaliation occurred. That's now been codified in the rules because of the Supreme Court's decision. So let's go to CFTC. Chris, tell us the big developments in the CFTC context.
Okay, well, we have not updated our rules in a while, but we have adopted some of the things that Jane just talked about. We have as well. So our programs are pretty similarly aligned at this point. The big thing, and it was just enforcement in general, is the self-reporting guidance and also the guidance with it on cooperation and how much we want to value cooperation at the CFTC. And the old adage is always with us, cooperation will be rewarded, and we wanted to make sure that we went out there and put it in writing, so there's a greater understanding with people out there who know if you engage the CFTC, there's certain things that are going to help you. So we've created a system of cooperation where the amount of cooperation you provide will fall into one of 4 buckets. And the greatest form of cooperation being self-reporting to the agency, coming in and giving us everything that we could possibly want. And if that occurs, we will do all we can to ensure that if there are any civil monetary penalties that are contemplated because of the gravity of the conduct, we will have a recommendation to the commission that they lower those out. The other end of the spectrum is no help at all. We simply we find out about something, we begin an investigation, we send subpoenas, and people respond to those subpoenas. They don't obstruct. That's the minimum. You're not going to get any credit for that simply because you have a legal obligation to do that. What we're looking to do is encourage people, incentivize them in different ways to come forward and give us helpful information. One of our greatest obstacles is just the amount of time that's associated with bringing any investigation. So the things that we talk about in these guidance, they very much mirror the concepts that we use in the whistleblower world. We talk about voluntariness, we talk about timeliness, specificity, and helpfulness of information. These are all the same concepts with just different incentives. In the whistleblower concept, we incentivize through potential payments of awards, whereas in the context of someone who's cooperating, they potentially can lower their exposure and the amount of money they may have to pay out ultimately. And this all mirrors what goes on also on the criminal side, where it's a person's liberty when someone is compromised. They're going to try to cooperate to the best of their ability to avoid being in prison, or at least being in prison for a shorter time. In furtherance of where we're going enforcement-wise, we've formed new task forces now that deal with specific areas that we oversee, and these have been very helpful to this point. We've got my old boss, Jamie McDonald, announced them a while back at a press conference, unbeknownst to me, so I was as surprised as everyone else. And they track some of our new areas of specificity: spoofing and manipulative trading, virtual currency, insider trading, and the Bank Secrecy Act. And so these task forces have been around for over a year now, I think, and we make sure that if something comes in through our system, that will go to them. We do our own triage within the whistleblower office to make sure that the folks in those task forces are made aware of them. We are collaborating very well with the SEC on cryptocurrency. In the past, unfortunately, our two agencies sometimes had difficulty determining how best to define jurisdiction when there's potentially jurisdiction involved in both. They have, at least to this point, pretty much ceded the crypto space, the virtual currency space to us, whereas they deal with the virtual coins and the coin offerings. The amendments to Dodd-Frank give the CFTC anti-fraud jurisdiction over the underlying commodities themselves. And the courts have agreed with our assertion that a cryptocurrency asset is, in fact, a commodity as defined in the CEA. So we brought a number of cases with that being the basis of our jurisdiction, and we'll continue to do so. Obviously, we don't have the safety and soundness prudential regulation. No government agency does at this time, but we do retain the ability to bring an anti-fraud action, which is similar to how the SEC dealt with swaps prior to Dodd-Frank. And then obviously when Dodd-Frank was enacted, swaps jurisdiction was moved exclusively over to the CFTC, anti-fraud and prudential. And then finally, we are continuing education and outreach both to consumers or customers, or as you would define them as investors, although you really don't invest in our markets. It's a market of derivative actions that don't have any intrinsic value that you hold on to. Their purposes of creating price certainty and hedging risks. But we want to make sure that folks who do participate in markets that we regulate, that we make them aware of potential harbingers of fraud, the red flags you want to look for to protect people as best we can. And also, we've been issuing what we call whistleblower alerts that mirror the subject matter areas I discussed with the specific task forces, where we talk about to let folks know in the space and also counsel, what we're looking for. And all the resources that I've talked about are available at our website, www.whistleblower.gov. You can find it there, or you can also go through cftc.gov, and there's a portal that'll get you through to our website. But all the information about what we do there is available on our website. So I encourage people to visit that, and you'll find everything that you need.
Oh, that's great, Chris. We had Jane give you folks the 800 number. The CFTC, being at the cutting edge of the technology world, has given you a website. I suspect the SEC has their own website, and you guys will all find your way there. You mentioned, Chris, Bank Secrecy Act, and that kind of gives me a little opening to have some breaking news, to use the phrase of the day. In the defense bill that is working has now been mostly worked out in Congress, and we'll see whether the president signs it. There's a new whistleblower provision for violation of the Bank Secrecy Act and money laundering rules. And so for the first time, we are going to have whistleblowers who report Bank Secrecy Act violations, assuming this does get signed by the president, will be eligible for a reward program. And so that is brand new. And some of us have been agitating for such a program for a long, long time. The only caveat is that at the moment, there is no floor. There is no guaranteed minimum. They modeled the CFTC and SEC programs with this legislation. For some reason that is really hard for me to fathom, they do not have a minimum, which, in the case of the SEC and the CFTC is a minimum 10% award. So we're hoping that that'll be fixed with regulations when the Department of the Treasury writes regulations for this brand new whistleblower program, which I think will be massive. Or at least, of course, I hope it will be. But this has been something that we've seen a need for a very long time. So all those worldwide money laundering schemes, if any of the folks in the audience are running one of those worldwide money laundering schemes, watch out for your employees and confidants. Okay, IRS. Dawn, tell us what's going on at the IRS these days with whistleblower programs.
Okay, so we have not had any new developments in the past year, but it does seem that on an annual basis, Congress does amend our statute. So we're constantly amending our program to match the statute. In 2018, under the BBA, they did add 7623C, which was huge for the IRS and for the whistleblower community. The way the statute was amended, the term proceeds now includes penalties, interest, additions to tax, and additional amounts provided under internal revenue laws. In the past, those amounts did not include criminal fines, FBAR penalties, failure to file information reports, Title 18 money laundering statutes. So this definitely opened a broad range of proceeds for which we can pay whistleblowers. This was a huge, huge change to our program. In addition to the 2018 amendment, we had the July 2019 amendment under the Taxpayer First Act, which also included anti-retaliation protections. Although the statute is updated, the IRS does not enforce the anti-retaliation protections. It is another federal agency, but it was important because we are constantly hearing from our whistleblowers about retaliation. And since this was not something that was built into the original 7623 amendments in 2006, it is something we were very happy to see in the amendments. Just to back up a little bit, I did want to cover something that Jane mentioned in her slides. She mentioned that there's a way to perfect your claim. Unlike the SEC rules, the IRS does require that the information be submitted under penalties of perjury, which means you need to provide that Form 211 when you provide the information. The Form 211 must be signed under penalties of perjury. And there is only one intake point for that form, and that is the IRS Whistleblower Office. So if you were to call our tip line, or if you were to give the information directly to the Department of Justice or to another IRS function without providing the Form 211, we cannot pay on that information. We have set a time frame for perfection, and that is at the point that the IRS takes an administrative action. So if you come in and you meet with a criminal investigator or you meet with the Department of Justice related to the allegations, and the information is being evaluated, but we haven't actually shared the information or shared the tip with an investigator who would go out and take action on that information, you still have time to perfect. So it is very critical that when you're meeting with, a lot of our whistleblowers do go directly to the Department of Justice or do go directly with to a criminal investigator. When you are meeting with these criminal enforcement agencies and the Department of Justice, you need to provide that Form 211 signed under penalties of perjury at the time that you are meeting with them. So just keep that in mind. That is a critical difference between the IRS program and the SEC program.
Okay, so let me ask you one thing about that, Dawn, because I think that's an important point. So just so I summarize this correctly, if you have a client come into your, if we have a client that comes into our office, a whistleblower, and they have an SEC case, if they've already spoken to the SEC, there's a clock that could be ticking. If they've already disclosed their information to the SEC. With the IRS, it sounds like there's no clock. In other words, if we have a client who comes in and you haven't sort of sent things out and there's no examination process that's been kicked into gear here, but they have gone to the IRS and spoken with them, there's not an IRS clock that is ticking that says if you don't get your Form 211 in by X date, you'll be blocked. Is that correct?
That is correct. There is no clock. Okay. But we need the Form 211 with the signed penalty of perjury before any action is taken. Otherwise, you may be denied the claim for untimely filing. So you need to make sure if a client comes in and they said, I talked to the DOJ or I talked to CI, I would do that form immediately. Get that into the IRS, and then we will determine whether the claim is timely or not. We are a large organization. The whistleblower office does not take the actual enforcement actions. So there is the possibility that no action has been taken based on that information if the form is timely. So for example, you have a situation where you're aware of someone rerouting refund checks. So you have a refund scheme and you're actually in possession of those illegal checks, and you call TIGTA, the Treasury Enforcement Investigation Government Agency, or you call our criminal investigation folks and you say, listen, I have these checks and they showed up in my mailbox. CI goes out and they collect the checks, and you realize, oh, I want an award for this, but you didn't sign the Form 211. You get the Form 211 in the next day. We will be having an in-depth conversation about the timeliness of that Form 211 because the action was already taken to get the checks. It is critical that you get that Form 211 in up front versus a situation where you go into the Department of Justice for a proffer and you lay out your scheme, and then you go home and you think, oh, I really need to talk to a whistleblower attorney about this. And you go and you talk to the whistleblower attorney and you put together a package. And while you're putting the package together, the Department of Justice attorney calls you and says, I have some follow-up questions about our meeting. And then you go back in and you meet with them. And you provide the Form 211 and all of this additional information. In that situation, there's not a likelihood that they would have taken any action or that they would have even contacted the IRS regarding this initial meeting. So there is still time to perfect that. So the critical information here is if you're meeting with the IRS voluntarily, or if you're meeting with the Department of Justice voluntarily regarding any section of the law in which the IRS has the authority to oversee and enforce, you need to bring that Form 211 with you.
Okay. Well, those are great pointers. And in fact, the next thing I want to talk about really quickly are some very practical considerations. So the things I wanted to make sure to emphasize to our group are, first of all, you should file electronically with the SEC and the CFTC. They strongly urge you to use their online, especially these days with COVID. You need to understand there aren't like thousands of people working at the SEC's headquarters office building these days, waiting for your tips to come through the mail. So go online with them. Now, on the IRS, they do not have an
Eric,
online
can I just
file.
mention one quick?
Yes, go ahead, Jane.
I'm sorry, Eric, to interrupt, but one thing I wanted to just note is that if you do decide to mail something into us, there is an alternative mailing address. Don't send it to our headquarters. Because of COVID, that is not where we are collecting mail anymore. There is an offsite location in Virginia. And if you go to sec.gov/whistleblower, you're going to see where to mail it. Please submit it electronically if you can, or fax it. And in fact, today we're making live as part of that app, that new app rollout, we're actually making an email box to make it easier for people to send in apps during COVID.
Great. That's really good to know. And by the way, do not both submit an online version of the form to the SEC and the CFTC and a mail form. That's just going to cause confusion. So pick, and the preferred pick is electronic. But if you choose electronic, don't do belt and suspenders, because it's not belt and suspenders. You've just cut your suspenders and your pants are falling to the ground. So with the IRS, send it by mail. Second point I wanted to make is make sure your submission is specific, detailed, timely, and that you provide ongoing assistance to the agencies. That will boost your reward, especially the timely part. You submit something where your most recent information is 5 years old, and that submission is going to go to the bottom of somebody's stack. And that's not where you want it. These are agencies with very limited resources. You want your submission at the top of the stack. You also know that you can get a reward by providing assistance even if there is an existing investigation. So if the whistleblower comes in and you've seen a story on the front page of the New York Times about this same fraud scheme, but your client has unique and non-public information that would be of significant assistance to the investigation, you should go ahead and submit the tip to the IRS, the SEC, or the CFTC. I was surprised to see that 29% of the SEC awards to date have been for whistleblowers who provided assistance to an ongoing investigation. And finally, if your client has just gotten pulled together a bunch of public information and in a way that wasn't really obvious to others, then they can be a whistleblower simply by synthesizing that information and, not just like putting two newspaper articles together and saying, here it is, but really doing some sort of independent analysis that can qualify as well for a program. I want to ask one quick question, by the way, for Dawn, because I want to make sure we get to it. Dawn, the IRS is very, we have a lot of people in the audience, I think, who work for asset search firms, who locate assets around the world. What is the IRS's attitude toward a whistleblower whose only contribution to the IRS recovery is to identify worldwide assets someplace where the IRS had been unable to find those assets?
We do include collection-only cases in our award determinations. So in a situation where you do have someone hiding assets around the world and we are not aware of those assets, and we are able to seize those assets or encourage the taxpayer to sell the assets to pay, we will pay the same 15 to 30% on the collection efforts related to those assets. We also pay on revenue protection. So in the situation that I was describing, where you were able to stop illegal money, illegal refunds from being paid to a criminal, we will pay on revenue protection as well. So any information that you have related to assets being held around the world, or stopping identity theft or refund crimes, you should file a Form 211 with that information.
Okay, thank you. Chris, how about the CFTC? Do you guys have any thoughts about this at this point?
At this point, collection for us is something we just don't do. Unfortunately, we don't have everything set up for it, so we have to send everything off to Treasury, but obviously any information provided to us, we will be happy to share with Treasury and hopefully to get some collections, because our whistleblower awards are contingent upon amounts collected. So anything that we can do, we will do to help collect, but we can't do much other than just be a conduit.
Okay, and Jane, how about the SEC?
So the SEC, we do have an Office of Collections, which consists of some very dedicated attorneys who do try to track down assets in order to get collections on our matters. And so same as Chris, our whistleblower award payments are contingent upon collections. So we do have collection efforts that do happen in-house. After some period of time, though, it does get turned over to Treasury, and we do sometimes get amounts that come in that we do pay awards on based on amounts that Treasury collects as well. So, collections is obviously critical to pay the whistleblower awards.
Okay, thanks very much. So let's go to some common schemes, and we'll spend a little bit of time on that before we turn to questions, as we have a few questions out there. And by the way, for the audience, if you do have questions for the panel, then you need to open your chat window to post those questions. It's the little, at least on my computer, it's a little square-ish kind of quote. It's almost like a thought bubble, but it's kind of square. And you open that window, and then you can type your questions in there. And operators are standing by. So let's talk about COVID-19 schemes. Of course, COVID's on everyone's mind, and I think that we have some. It's a little premature to see exactly a lot of large COVID schemes. The ones that we've seen so far have been relatively small crimes, but of course, with a few $1 trillion sloshing around out there, it's likely we're going to see more. And typically, there's some historical perspective here. We've seen that fraud follows financial decline. So I'll ask Chris. There's something about this in the CFTC's annual report to Congress. Can you talk a little bit about what you've seen historically?
Yes, and you are correct. Fraud absolutely follows financial decline. We saw it after 2008, and we're seeing it here with COVID as well. Our higher TCR numbers, I don't know if they're necessarily because there's more activity out there or simply that people have more time on their hands to send us TCRs, but we very much appreciate it, and we're getting a tremendous amount of information sent to us, and we very much appreciate it. And some of it does relate, in fact, to COVID. And we have brought 2 enforcement actions relating to people attempting to raise money in connection with fraudulent schemes that would somehow be able to take advantage of inside information about how the futures market will react in accordance with various COVID-19 strategies and things of that nature. So we're seeing a lot of it. We're seeing COVID TCRs coming in, but not all of them are COVID related. I think what's going on here, if we just have a much more attentive public and maybe a little more incentivized to send us stuff. But like I said, keep them coming. It's always good to hear because more is always better.
And you alluded to an increase in tips that you have seen. Jane, has the SEC also seen an increase in submissions from whistleblowers since the economy has cratered?
Yeah, definitely. We had a big uptick this year. I think we're almost, 6,900 whistleblower tips as compared to 5,100 last year. So it was a huge uptick. A lot of them coming in kind of when the country shut down in March. There's who knows why that is, but certainly people are sending things in. In response specifically to COVID, the SEC did create a coronavirus steering committee, and that steering committee proactively identifies areas of potential investor and market risk. The one thing that they have done is we have suspended trading in 36 issuers and have filed 6 COVID-related fraud actions related to false and misleading claims about COVID-related capabilities. And you may have seen just on Friday, the Commission also charged an entity for reporting and disclosure violations related to false statements regarding operations during this time of COVID.
All right. So we've got a bunch of questions, and rather than slog through the rest of our presentation, which goes into some other areas of fraud and enforcement priorities, such as the CFTC and cryptocurrency, I'll just refer the audience to those slides. You can see there are some just lists of FCPA cases and cryptocurrency cases that you can see there. Those are 2 hot areas right now. And so I'm not going to bother to go through those because I think we'd be good to turn to the questions. So first question we have is someone asks, about the timing of awards, about estimated time between the end of the enforcement action and the determination of the award. Dawn, do you want to talk about that? The IRS is kind of a complicated answer to that question, I know.
That is a very complicated question.
We do only have 10 minutes left. So.
Okay. I really cannot give you an average for the amount of time. Our enforcement action goes all the way through full collection after the taxpayer has availed themselves of all of their rights to pay, and that can take up to 10 years for them to full pay. And then in situations where they haven't agreed and they've gone to the Supreme Court for a determination, it can be a much longer process. So we unfortunately do have claims that are over 20 years old. So it really depends on where you come in. Of course, if it's a purely collection situation and you're bringing us the assets, you're shortening that period for collection, that would be great. But if you're bringing us the tip that starts the initial audit, it could be many, many years.
Okay, and quickly from the CFTC and the SEC, Chris, about how long, do you have any information on time from enforcement to award?
We haven't calculated that, and there really is no right answer to that because everything is so unique. And I hate having to tell people that we endeavor to do everything as quickly as we can.
No.
So many.
The right answer is 3 weeks, Chris.
Exactly. I was just about to get to that. Yeah, I wish. And the things that complicate it the most is you got multiple whistleblowers in these actions, oftentimes. And we have to figure out exactly what happened. And oftentimes it's also a lot of data that we're going through and just figuring out the right answer. And also just being a government agency, there's a lot of oversight within the agency itself. So we have our attorneys within our office looking at it, our attorneys in the Office of General Counsel looking at it. Then we have to sort of figure out the recommendation that we're going to make to the CRS. And then depending on how that works, there can be reconsideration, and it can take a significant amount of time. So it's gonna take a while, I think, just back of the envelope. I mean, we're doing good if we can get something out in 12 to 18 months, but sometimes they take even longer than that.
All right. And Jane, how about the SEC? I know you guys have done things to reduce your backlog. What is your timing looking like these days?
Yeah, we sure have. So, like Chris, I agree, first of all, with everything Chris just said about multiple whistleblowers, and the facts and circumstances can certainly add time onto the review and the processing of that claim. Like the CFTC, I don't have a number I can give you because it's just not that simple. But to give people some assurances that are listening today, I know I told you earlier that last year we had a record-breaking year. We did put in place some efficiencies that have allowed us to really move things much quicker. And with these new rule amendments, I also expect things to move much quicker. The one thing I will tell you is last year in our annual report to Congress, we had noted that we processed 315 claims to preliminary determination. For those of you who are familiar with the process, that's sort of the first answer from the claims review staff before it goes to the commission. And that's the largest number we've ever issued in any fiscal year. And that is a 167% increase over the last fiscal year. And if you've been paying attention to any press releases coming out, you'll note that we haven't slowed down at all in the first 2 months of this fiscal year. So I anticipate definitely shortening the timeline.
Well, that's good news. Okay, another question from the audience for Dawn. Dawn, let's say a person receives an award of $100 million. Does he or she receive the $100 million and the IRS then rely on him or her to pay their income tax? Or is it that the tax taken out up front, so they receive the $100 million minus whatever tax is potentially owed?
There is mandatory withholding. If it is a foreign whistleblower and they're in a treaty country, they can file a treaty request to withhold less based on the treaty of the country they're in. If it's a domestic, then yes, we automatically withhold 28%. So there is withholding, and there is also sequestration that comes out of that award.
Okay. Thank you for that. Now, this would be a question, I think, for any of the panelists, but does the agency have a view on the increasing prevalence of litigation finance? Is that on any of your radars? Let's start with Jane. How about the SEC?
Not really. I'm not sure if I understand exactly what the question is getting at.
Yeah, I can clarify a little bit. The Justice Department has recently raised an eyebrow over whistleblowers who get outside funding from financial companies in exchange for promising that the whistleblower will pay back a percentage of the reward. So the Justice Department has started to ask for details about that. The SEC doing that at all, or is that not something you're concerned about?
Certainly not on our radar right now.
Chris, Dawn,
same for us.
Any of yours? Okay. Another question we have is for Chris. What does it look like to monitor fraud over commodities? Does that mean that you have jurisdiction if there's fraudulent dealings in a commodity extraction project, even without trading fraud?
Great question and very in-depth. And the answer is it may be. It was something that was set aside just in case. We don't want to be in the business of regulating the commodities markets, the spot markets themselves. But that being said, we did want to preclude it. So if there's a material enough fraud in a particular commodity, it is of interest to us because that could potentially disrupt the marketplace. We want to make sure that the futures market exists to help supplement that. So yes, that is potentially something we could bring an action on.
Okay, and just to be clear, your whistleblower statute would encompass pretty much everything that you have enforcement authority over. So that would be 100%. The type of scheme.
Absolutely. Okay. Anything that any successful enforcement action that is brought is eligible for an award as long as it ticks off the other over $1 million and all through the statutory framework.
Okay. Dawn, we have the audience is paying attention, and they saw on the slide that we didn't really get to on your slide that there was a discussion of enforcement priorities, things like micro captives, conservation easements. You want to talk a little bit about those areas of IRS enforcement priorities?
Sure. The IRS does publicize our priorities. So if you go to the irs.gov website, each of the organizations will talk a little bit about the top 10 projects that they're working on, the schemes that we've addressed, the schemes you shouldn't fall for, micro captives, conservation easements, cryptocurrency. All of those things are on our priority list, along with the campaigns that LBNI prioritizes. And I would look to the Criminal Investigation Annual Report, the SBSE Annual Report for a list of those priorities.
Okay, well, that's great. For those of you in the audience, I don't know that you see the giant ticking clock that the rest of us see. It makes me feel like, I'm Jake Tapper and trying to make it to a commercial break, but we need to wrap up here. I want to thank all of you in the audience for joining us today, and I'd especially like to thank our panelists who are obviously the most knowledgeable people in the country about these programs, and thank you for your time and your effort. I hope all of you have a good day, stay happy and healthy, and we'll see you at some future Offshore Alert conference. Thanks very much.
Thanks for watching. Consider subscribing to our investigative news and documents service and attending our events. For more information, visit offshorealert.com.